17 minutes. That's how long the courtroom was supposed to be on break. 17 minutes for the jurors to stretch their legs, for the lawyers to grab coffee, for everyone to pretend this high-stakes federal fraud trial was just another day at work. 17 minutes before everything exploded, because somewhere between minute 3 and minute 4, a tiny red light stayed on when it should have gone off. A microphone on the defense table, the one they thought was muted, kept listening, kept recording, kept capturing a conversation that was never meant to be heard by anyone outside that small circle of power. And when Judge Caldwell came back through that side door, his face wasn't just stern, it was ice cold. No shuffling of papers, no small talk, no polite counsel, "Are we ready to proceed?" He walked in, looked straight at the defense table, and did something veteran attorneys in that room swear they have never seen in their entire careers. He ordered U.S. Marshals on the record in open court to seize the defense laptop, then the phones, then the tablets, then every external drive they could see, right there, in front of the jury, in front of the cameras, in front of a defense team that suddenly looked like they'd watched their entire professional lives flash before their eyes. So, what was on that recording? What did Judge Caldwell hear that made him suspend a high-profile federal trial in a matter of seconds, trigger a possible criminal investigation, and risk blowing up one of the most sacred protections in American law, attorney-client privilege? Because if you think this is just one judge having a bad day on the bench, you're not getting the full story. What you're about to hear doesn't just raise questions about one laptop. It raises questions about the entire system that's supposed to protect you. To understand why this moment hit like a legal earthquake, you have to understand who Judge Caldwell is. Not just the man in the black robe, but the institution he represents. Caldwell isn't some rookie magistrate learning the ropes. He's a seasoned federal judge, appointed years ago, known for his no-nonsense courtroom and his reputation for being meticulous to the point of obsession. Lawyers call him the clock. Not because he's slow, but because when he moves, it's precise, deliberate, inevitable. For years, defense attorneys and prosecutors alike walked into his courtroom knowing two things. First, he was tough. Second, he was predictable. He followed the rules, almost to a fault. He respected precedent. He rarely raised his voice. He believed in process, motions, hearings, evidence, objections, the boring stuff that actually keeps the justice system from turning into a circus. In legal circles, Caldwell was the guy you didn't have to like, but you had to respect. He wasn't a cable news judge chasing viral moments. He wasn't making dramatic speeches for the cameras. He was the opposite of that, which is exactly why this moment, the laptops, the marshals, the sudden seizure of defense electronics, landed like a bomb. Because if a judge like him goes nuclear in open court, something went very, very wrong. Here's where it starts to get uncomfortable. According to courthouse sources, the recording began during what everyone thought was a routine recess. The jury left. The judge stepped away. The public shuffled out to check their phones. The defense team stayed behind at their table. Standard protocol says the courtroom audio system should stop recording, but this time, it didn't. One mic stayed live. We're told the key part of that recording, the part that changed everything, lasted around 45 seconds. Not an hour-long conspiracy call, not a detailed legal memo, just 45 seconds of raw, unfiltered truth that no one intended to put on the record. In those 45 seconds, you had a member of the defense team, a reference to a witness, and language that, according to multiple legal analysts, sounded a lot less like defense strategy and a lot more like witness management, not prepare the witness, not help them tell the truth clearly, but make sure they remember what we need them to say. That phrase, what we need them to say, is where everything starts to twist. Because in a courtroom, there's a massive difference between getting someone ready to tell the truth and grooming someone to stick to a story that protects your client, no matter what. A staffer monitoring the audio feed flagged it almost immediately. Standard procedure says anything unusual has to be reported up the chain. Within about a minute, that recording was in Judge Caldwell's chambers. He listened once, not twice, not 3 times with lawyers present, just once. Then he stood up, straightened his robe, and walked back into that courtroom. That's the moment you saw on camera, the one going viral right now. the one where a federal judge, calm but visibly done with the games, ordered the seizure of every device the defense team had brought into that room. And if you're watching this thinking, okay, but isn't that overkill? Isn't that a violation of attorney-client privilege? You're not alone. Legal experts are deeply divided. Some say this was a bold stand against potential obstruction of justice. Others say this was a terrifying overreach that could haunt every defendant in America. We'll get to that, but first, you need to understand why this 45-second mistake was not a random fluke. Because here's what nobody wants to admit publicly. This didn't come out of nowhere. According to people familiar with the case, Judge Caldwell had been watching this defense team closely for weeks. This wasn't a slip-and-fall trial. This was a high-profile fraud case with millions of dollars at stake and political implications hovering in the background. Whispers had already started. Court staff talking quietly in hallways about strange meetings with certain witnesses. Prosecutors noting inconsistencies between what witnesses said in earlier interviews and what they suddenly remembered on the stand. Subtle changes in language that made seasoned lawyers raise an eyebrow, then another. One former federal prosecutor, speaking on background, put it like this: "You don't get a reaction like that from a judge unless the recording confirms something he already suspected." Think about that. Not created suspicion, confirmed it. There had been motions behind the scenes, rumors of undisclosed contacts, questions about whether someone on the defense team was doing more than just preparing people to testify. On paper, you call it witness tampering. In real life, you call it what it is, manipulating the truth. So when that recording landed on Caldwell's desk, it didn't appear in a vacuum. It fell into a story that was already unfolding, a quiet pattern of red flags, all pointing in the same direction. And that's why what happened next wasn't just a rash emotional outburst. It was the execution of a plan. This is the part most people miss, because we tend to talk about cases like this as if it's just one bad actor, one reckless lawyer, one judge losing it from the bench. But nothing like this happens in isolation. For weeks, multiple systems had been watching. Courtroom staff monitoring live audio, the clerk's office handling technical feeds, the U.S. Attorney's Office following the trial blow by blow, security protocols that require unusual recordings to be preserved and escalated. Caldwell didn't just hear the recording and improvise. According to reporting, he had already been in contact with federal prosecutors earlier that day, and possibly even before that, about concerns over the integrity of witness testimony in this trial. So by the time those marshals started bagging laptops in front of a stunned jury, investigators were already being alerted. The FBI's Public Corruption Unit later joined the case, a sign that authorities believed this could be bigger than a single sketchy conversation. In other words, while the defense team thought they were playing the game, the system had quietly started playing them. But here's the uncomfortable truth. This system that kicked into gear is the same system that supposedly missed the warning signs, if not for weeks, maybe for years. How many times had defense teams, prosecutors, or even judges gotten too close to the ethical line before anyone hit record? How many conversations just like this one have happened in hallways, conference rooms, and whispered chats that never accidentally fed into a live microphone? If you're watching this thinking, this sounds like a TV show, not a real courtroom, ask yourself, is this the first time it's happened, or just the first time it got caught? Let's go back into that room. The jury files back in. The defense team is still scrolling, clicking, whispering. They don't know yet that anything is wrong. Caldwell takes the bench. No smile, no easing into it. He states very clearly that during the recess, the court's audio system captured a conversation that raises concerns about potential witness interference. Lawyers at both tables freeze. The courtroom, according to people who were there, goes silent in a way that feels physical. Then he says the words that change the temperature of the room. All electronic devices belonging to the defense team will be seized. Laptops, phones, external drives, everything. The jury is ushered out. Reporters in the gallery can hardly type fast enough. The defense team objects loudly. They say this is outrageous, unconstitutional, a blatant attack on attorney-client privilege. Caldwell cuts through it. What's outrageous, he says, isn't the seizure. What's outrageous is what he heard on that recording. Within seconds, U.S. Marshals move in. No drawn guns, no shouting, no Hollywood. Just gloves, evidence bags, labels. They start with the laptop that had been sitting open on the defense table, then the phones, then the tablets, then any external storage device in sight. It's 40 seconds. That's how long it took for years of case prep, strategy, emails, and files to suddenly become government evidence. If you believe in due process, this is where your stomach should knot up a little. Because those devices don't just hold potential evidence of wrongdoing, they also hold confidential communications between lawyers and their client. In theory, that's sacred ground. In practice, Caldwell just turned it into a crime scene. Don't go anywhere, because what happens to that data next is where this story turns from shocking to dangerous. Let's talk about the line Judge Caldwell is walking here. Under American law, attorney-client privilege is one of the most powerful protections there is. It allows you to tell your lawyer the truth, the ugly, messy, incriminating truth, so they can defend you fairly. Without that protection, the system collapses. People lie to their lawyers. Lawyers can't build real defenses. Trials become theater. But there's one big exception, the crime-fraud exception. That's the rule that says attorney-client privilege does not protect communications that are part of an ongoing crime or fraud. You can't use your lawyer as a shield while you plan to break the law. You can't hide behind privilege while you tamper with witnesses, destroy evidence, or script false testimony. Legal experts who support Caldwell's move say that's exactly what he suspected, and that the recording gave him enough to act immediately. They argue he was not rifling through a defense team's secrets for fun. He was preserving potential evidence of a crime before it could be wiped, edited, or destroyed. On the other side, defense advocacy groups are sounding the alarm. They're warning that once you normalize a judge seizing defense electronics based on a single recording, every defendant in America has to wonder, if my lawyer says the wrong phrase in the wrong tone at the wrong time, do we lose our privilege forever? One civil liberties attorney put it bluntly. If this becomes standard practice, no one will ever fully trust their own legal counsel again. So, who's right? Was this a courageous stand against a corrupt defense team, or a terrifying precedent that could be abused the next time a judge doesn't like what they think they heard? And more importantly, what does that mean for you? If you ever find yourself sitting at a defense table, trusting that your conversations are protected, within hours, this case left the courtroom and entered the arena where every modern legal drama gets decided, the court of public opinion. Cable panels lit up. Constitutional scholars, former prosecutors, and defense attorneys all took their corners. One side says, finally, a judge who isn't afraid to crack down on dirty tactics. They argue that if the defense team was trying to shape witness testimony, they weren't practicing law. They were helping run a conspiracy, and conspiracies deserve handcuffs, not privileges. The other side says, this is judicial tyranny. That was the phrase used by lead defense counsel when he stepped in front of cameras outside the courthouse, face flushed, accusing Caldwell of destroying the defendant's right to a fair trial. So now you have two Americas watching the same 40-second clip of Marshals bagging a laptop and seeing two completely different stories. In one reality, Judge Caldwell is a hero, drawing a line in the sand and saying, "Not in my courtroom." In the other, he's a threat, a powerful judge using corruption as an excuse to bulldoze constitutional protections. And here's the dangerous part. Both realities feel true to the people living in them. If you already believe the legal system is full of slick lawyers gaming the rules, this looks like overdue accountability. If you already believe the government overreaches and targets certain defendants, this looks like the playbook in action, again. So, who's telling the truth? Or is the truth bigger than either side wants to admit? If you're watching this thinking, I'm never going to be in federal court, why should I care? Stop. Because what happens in a room like this doesn't stay in that room. It becomes precedent. It becomes standard practice. It becomes the quiet rule that suddenly applies to you if anything in your life ever goes sideways. Here's what's already happening behind the scenes. Federal investigators are reportedly combing through cloned copies of those seized devices, reconstructing timelines, mapping communications, and looking for patterns. The FBI's Public Corruption Unit is involved, suggesting they think this might go beyond one defendant and one trial into a broader network or repeated pattern of misconduct. Defense organizations are drafting challenges, ready to argue that the seizure was unconstitutional and that any evidence pulled from those devices should be suppressed. If the courts eventually uphold Caldwell's move, it sends a message. Judges have wide latitude to act fast and hit hard when they believe the integrity of the trial is at risk. If the courts strike it down, it sends a different message. Even in the face of suspicious behavior, the system will bend over backward to protect defense rights, even if that means some games go unpunished. Either outcome has consequences for democracy, for faith in the courts, for whether you believe the law is a shield for the powerless or a weapon for the powerful. Let's strip away the legal jargon and talk about what this really means for you, your family, and your future. If you, or someone you love, is ever charged with a crime, fairly or unfairly, your lawyer is supposed to be your safe place, your last line of defense in a system that can steamroll people who don't know how it works. This case cracks that safety net. If judges feel more empowered to step in, seize devices, and pierce privilege based on what they deem suspicious, then every conversation becomes a risk calculation. What if this sounds bad out of context? What if someone misinterprets a phrase you said out of frustration as evidence of a scheme? What if a technical glitch, just like that forgotten microphone, turns a private strategy talk into Exhibit A in a criminal investigation? And if you're watching this thinking, well, I'll never break the law, so I'm fine, remember this. People end up in court for all kinds of reasons. Sometimes they're guilty. Sometimes they're innocent. Sometimes they're somewhere in between, caught in a system that doesn't always see nuance. In every one of those scenarios, the trust between you and your lawyer can be the difference between freedom and decades behind bars. That's what's at stake here. Not just one laptop, not just one judge. The basic question of whether the system wants the truth, or just a win. And here's the part that should keep you up at night. We still don't know everything that's on that recording. Court filings suggest the audio may be longer than what's been described publicly, with portions referenced but not fully played in open court. There are hints of more players, more conversations, more moments where the line between legal advocacy and outright manipulation gets blurry. Was this one rogue attorney going off script? Was it a culture inside that defense team? Or was it part of a broader network? A pattern of cases where witnesses are quietly steered, stories are subtly aligned, and the truth is treated as just another variable to be managed? We don't know yet. What we do know is that Judge Caldwell has moved to keep part of that audio under seal, a decision that suggests there's something on there that could inflame the situation even further if it went fully public. That raises its own question. Is that secrecy protecting the integrity of the investigation or protecting the system from embarrassment? If you're still here, ask yourself this. Do you trust the people in charge of this process to police themselves? Do you trust judges to always know where the line is between preserving justice and overstepping their power? Do you trust prosecutors not to take a precedent like this and push it further the next time they feel a case slipping away? Because once a door like this is opened, once a judge has seized a defense team's laptop in open court after a secret recording leaks, it doesn't easily swing shut again. Other judges are watching, other prosecutors are watching, other defense teams are taking notes and wondering how exposed they really are. And somewhere out there, another microphone will stay on when it should be off. Another private conversation will end up in the wrong hands. Another judge will face the same choice Caldwell did: protect the bubble of privilege or pierce it in the name of the truth. So here's the haunting part. The real question isn't just what happens to Judge Caldwell, or to this defense team, or even to this one high-profile trial. The real question is what happens to us if this becomes normal. If the system missed this for weeks, maybe longer, what else is it missing? How many other conversations, other cases, other quiet manipulations are out there right now, shaping verdicts, deciding futures, rewriting lives in ways we'll never hear about because the mic never stayed on? If you want more real accountability stories like this, stay tuned. Because this case, this laptop, this 45-second recording, they're not the end of the story. They're the first crack in a wall that's been hiding far too much for far too long.